Chapter 12. Seamen. Concluded. Recovery of wages. Interest on wages. Salvage. Recovery of wages. A seaman has a threefold remedy for his wages. First, against the master. Secondly, against the owners. And thirdly, against the ship itself and the freight earned. B. 254. He may pursue any one of these, or he may pursue them all at the same time in courts of admiralty. He has what is called a lien upon the ship for his wages. That is, he has a right at any time to seize the vessel by a process of law, and retain it until his claim is paid, or otherwise decided upon by the court. This lien does not cease upon the sailing of the ship on another voyage, and the vessel may be taken, notwithstanding there is a new master and different owners. 2 Sumner 443. 5 I didn't read the footnote again. I failed to 2 Sumner 443, 2 Gall 398. He may pursue any one of these, or he may pursue them all at the same time in courts of admiralty. He has what is called a lien upon the ship for his wages. That is, he has a right at any time to seize the vessel by a process of law, and retain it until his claim is paid, or otherwise decided upon by the court. This lien does not cease upon the sailing of the ship on another voyage, and the vessel may be taken, notwithstanding there is a new master and different owners. 2 Sumner 443, 5 Pet R 675. A seaman does not lose his lien upon the ship by lapse of time. He may take the ship whenever he finds her, though he must not allow a long time to elapse, if he has had any opportunity of enforcing his claim, lest it should be considered a stale demand. In common law courts a suit cannot be brought for wages after 6 years have expired since they became due. This is not the case in courts of admiralty. 2 Gall 477, Payne C.C. 180, 3 Mason 91. The lien of the seaman for wages takes precedence of every other lien or claim upon the vessel, where 134:41. The seaman's wages must be first paid, even if they take up the whole value of the ship or freight. The wreck of a ship is bound for the wages, and the rule in admiralty is that a seaman's claim on the ship is good so long as there is a plank of her left. 3 Sumner 50, 1 Ware 41. If, after capture and condemnation, the ship itself is not restored, but the owners are indemnified in money, the seaman's lien attaches to such proceeds. 5 Pet R 675. Besides this lien upon the ship, the seaman has also a lien upon the freight earned and upon the cargo, where 134, 5 Pet R 675. He may also sue the owner or master, or both, personally. They are, however, answerable personally only for the wages earned while the ship was in their own hands. 11 Johns 72, 6 Mass 300, 8 Mass 483. But a suit may be brought against the ship after she has changed owners. 5 Pet R 675, 2 Sumner 443. A seaman does not lose his lien upon the vessel by taking an order upon the owner. Where 185. After a vessel is abandoned to the underwriters, they become liable for the seaman's wages from the time of the abandonment. 4 Mason 196. If at the end of the voyage the crew are discharged and not retained to unload, their wages are due immediately. Where 458. Dunlop ad PR 99, 1 Pet ad 165, 210. But they cannot sue in admiralty until 10 days after the day of discharge. Act 1790, Chapter 56, Section 6. If they are retained to unload, then the owner is allowed 10 days from the time the cargo is fully discharged. If, however, the vessel is about to proceed to sea before the 10 days will elapse, or before the cargo will be unloaded, the seaman may attach the vessel immediately. Act 1790, Chapter 56, Section 6. If the owner retains his crew while the cargo is unloading, he must unload it within a reasonable time. 15 working days has frequently been held a reasonable time for unloading, and the 10 days have been allowed to run from that time. 1 pet ad 165, Abbott on shipping 456 N. The longest time allowed by law for unloading vessels is 20 days if over 300 tons. Is 20 days if over 300 tons, and 10 days if under that tonnage. Probably seamen would not be held bound to the vessel for a longer time than is thus allowed by law for unloading. Recovery of wages in England. As regards wages not exceeding £20, it is provided by the Acts 5 and 6 William IV, Chapter 19, that it shall be lawful for any justice of the peace residing near to the place where the ship shall have ended her voyage, cleared at the custom-house, or discharged her cargo, or near to the place of residence of the master or owner, upon complaint on oath by the seaman, or on his behalf, to summon the master or owner before him, and to examine upon the oath of the parties, and of their witnesses, if any, touching the complaint and the amount of wages due, and to make order for payment as shall appear to him to be reasonable and just. And that in case such order shall not be obeyed within 2 days after the making, such justice may issue his warrant to levy the amount awarded, and all expenses, by distress and sale of the goods of the party upon whom the order shall have been made. And if sufficient distress cannot be found, may cause the amount to be levied upon the ship and furniture, and if they be not within his jurisdiction, may cause the party upon whom the order shall be made to be apprehended and committed to jail, until the amount, with all costs, shall be paid. Which award and decision is to be final and conclusive on both parties. Section 15. And in order to enforce the adoption of this remedy, it is by a subsequent clause enacted, that if any suit for wages instituted in an admiralty court, or in any court of record in the British domains, it shall appear to the judge that the plaintiff might have had an effectual remedy by the mode above prescribed, the judge is to certify accordingly, and thereupon no costs of suit are to be awarded to the plaintiff. Section 16. The burthen of producing the written contract in cases of dispute with the mariners is cast on the master and owners. Section 5. All suits and actions brought in the Court of Admiralty for seamen's wages must be commenced within 6 years next after the wages become due, unless the party entitled to sue shall at that time be under the age of 21 years. A femme covert, non compos mentis, or imprisoned, or unless such party, or the party sued, shall be at that time beyond the seas, in which cases the suit may be brought within 6 years after the party suing shall be of full age, discovert, of sane memory, or at large, or either the party suing or the party sued shall return from beyond the seas. 4N. Chapter 16, Sections 17, 18, and 19. And actions in the courts of common law are also limited to the same period of 6 years, with the same provisos, unless they are founded on a contract under seal, and if they are founded on such a contract, the statutable limitation does not apply to them, but after a lapse of 20 years, the claims will be presumed to have been satisfied without any proof of payment. Abbott, 595. As to the time of wages becoming due, see the note to Chapter 11, page 249. Interest on wages. In suits for seamen's wages, interest is allowed from the time of the demand, and if no demand is proved, then from the time of the commencement of the suit. 2 Gall 45. Interest on wages in England. It has been already stated that if the master or owner shall neglect or refuse to pay the seaman his wages when due, he becomes liable to forfeit to such seaman the amount of 2 days' pay for each day not exceeding 10 days, during which payment shall without sufficient cause be delayed. Chapter 11. See note to Chapter 11, page 250. If the seaman wishes to entitle himself to interest upon his wages, he should give a written notice to the master or owner of his intention to claim such interest if his wages be not paid within a given period. Salvage. If a vessel is picked up at sea, abandoned, or in distress, and any of the crew of the vessel which falls in with her go on board, and are the means of saving her, or of bringing her into port, they are entitled to salvage. Where 477, 1 pet ad, 306. In this case, all the crew who are ready and willing to engage in the service are entitled to a share of the reward, although they may not have gone on board the wreck. Where 477, 2 pet ad, 281. 2 Dodson, 132. The reason is that where all are ready to go and a selection is made, there would be injustice in allowing any one the privilege more than another. Besides, those who remain have an extra duty to perform, in consequence of the others having gone on board the wreck. 2 Dodson, 132. Crews are not ordinarily entitled to salvage for services performed on board their own vessel, whatever may have been their perils or hardships, or the gallantry of their services in saving ship and cargo. 10 Pet R 108, 1 Hag 227. For some degree of extra exertion to meet perils and accidents is within the scope of a seaman's duty. In case of shipwreck, however, where by the general law wages are forfeited, the court will allow salvage, considering it as in the nature of wages due. In one instance, salvage was refused to a part of a crew who rescued the ship from the rest who had mutinied, for this was held to be no more than their duty. 2 Dodson, 14. Yet seamen may entitle themselves to salvage for services performed on board their own vessel, if clearly beyond the line of their regular duty, as when the crew rise and rescue the vessel from the enemy after she has been taken. 1 Pet ad 306. So where a ship was abandoned at sea, and 1 or 2 men voluntarily remained behind, and by great exertions brought her into port. 2 CR 240, 1 Pet ad 48. If an apprentice is a salver, he, and not his master, is entitled to the salvage. 2 CR 240, 2 Pet ad 282. If one set of men go on board a wreck, but fall into distress and are relieved by others, they do not lose their claim for salvage, but each set of salvers shares according to the merit of its services. If the second set take advantage of the necessity and distress of the first salvers to impose terms upon them, as that they shall give up all claim for salvage, such conditions will not be regarded by the court. 1 Sumner, 400. Salvage in England. The crew of a British vessel cannot claim as salvers or joint salvers in respect of services performed on board their own vessel, not even in the case of shipwreck. 1 Hag ad Rep 227. For further information on this subject, the reader is referred to Abaddon Shipping, 6th edition, title Salvage. The end. Finis.